So the PHH versus CFPB case ruling came out, as we're all aware. Now, in that ruling, it states the CFPB has to follow the pre-existing 3-year statute of limitations on bringing cases, a law that Richard Cordray ignored. It also said the structure of the CFPB is unconstitutional and that one man, unaccountable to anyone, has too much power, which he does, yet the ruling does virtually nothing to abate the CFPB structure or dilute the power of the director.
According to the Wall Street Journal, because one man runs the powerful Consumer Bureau, the court observed that he enjoys more unilateral authority than any other officer in any of the 3 branches of the United States government other than the president. He also possesses enormous power over American business, American consumers, and the overall U.S. economy.
And that Mr. Cordray can issue new rules, determine how and when to enforce them, decide against whom they will be enforced, and dictate what sanctions and penalties to impose, which he does, and he did in the case of PHH, amongst others.
Now, our assertion is this ruling will do nothing to stop, slow, or hinder Richard Cordray in achieving his objectives. That's because the only significant change in the court's ruling is that the president can now fire Richard Cordray without cause. The problem is the president doesn't want him gone, thinks he's doing great, so nothing's gonna change. Now, is this bad? Well, to answer that question, we want you to consider Richard Cordray and the CFPB's ruling about arbitration clauses and the long history of Richard Cordray that dates back to his days as Ohio Attorney General and how the current proposed new rule of admonished arbitration clauses in contracts comes at the expense of consumers and to the benefit of his donors, that being class action lawyers. This isn't going to be what you think, and you should be furious with what you're about to hear.
One man, Richard Cordray, with absolute unquestioned authority, wiped out arbitration clauses that had been the law of the land since 1925 and upheld by the Supreme Court of the United States, and to the benefit of his lawyer buddies and contributors, while at the expense of consumers that he has been tasked to protect. This is not a coincidence.
While Attorney General of Ohio from 2009 to 2011, Richard Cordray had a track record of handing out hugely enriching class action lawsuits to law groups that contributed to his political party. For example,
according to the Civitas Institute, from 2008 to 2010, the law group Labaton donated at least $125,000 to Ohio's state Democratic Party. Their generosity was rewarded in a big way. In July of 2011, they were lead counsel in one of the largest class action settlements in history, representing the Attorney General's office and 3 major Ohio public pension funds. The Ohio Attorney General at the time, Richard Cordray.
And over a 2-year span while Attorney General, Cordray pulled in $830,000 from out-of-state plaintiffs' law firms, including $270,000 from Kaplan, Fox, and Kilshemer, and $175,000 from Bernstein, Litowitz, Berger, and Grossman, both New York shareholder class action specialists. These and other firms in turn netted millions out of the more than $1 billion in settlement dollars negotiated with Wall Street firms in the wake of the financial crisis.
And Cordray made this happen by sidestepping then existing Ohio law that forbade the state from entering into any contracts with a firm that has given more than $2,000 to the campaign of an official with oversight of the contract in question. He funneled contributions through the Ohio Democratic Party.
Sidestepping laws, handing out class action lawsuits that paid millions upon millions to those who donated to his party. Is this the person we want to have absolute power running the CFPB? Again, according to the Wall Street Journal, more power than anyone outside of the president. So what did he do with this power? Remember those class action lawsuits we just talked about that he doled out to his lawyer contributors while being the Ohio Attorney General? The top lawyer of the state? Well, let's just say he kept the party going.
On May 5th of this very year, the CFPB proposed a rule that would scrap arbitration clauses in lending contracts, which paves the way for more, you guessed it, class action lawsuits.
It's important to point out that arbitrations in contracts have been the law of the land since 1925, nearly 100 years ago, and by all accounts have worked out pretty damn well.
So, Will wiping away arbitration clauses to contracts help consumers? Well, let's take a look at the CFPB's study.
According to the CFPB's very own study, arbitration led to settlements or awards 63% of the time, where the average decision delivered was $5,389 to the consumer.
And in the other hand, class action cases, from Forbes, the CFPB's own 728-page report issued last year found that the minority of class actions filed between 2010 to 2013 that later settled delivered around $32 per consumer, while the lawyers took in $425 million in fees.
Further, and again, according to the CFPB study, arbitration cases tend to settle between 2 to 7 months, where many of the cases do not require representation from a lawyer. In fact, the CFPB determined that settlements were nearly identical between arbitration cases that retained counsel and ones that did not.
Class action cases absolutely require counsel and take years to litigate.
So let's review.
Class action takes years to settle, arbitration settles in months.
Class actions, the consumer averages $32. Arbitration, $5,389.
Class action lawyers earned $425 million over the course of the CFPB study. Arbitration lawyers are not even required or necessary.
Class action, less than 20% of participants get any type of reward at all. Arbitration, 63% get reward or settlement.
So according to the CFPB study on arbitration clauses in contracts, you would have to conclude that arbitration is better for consumers in every way, shape, and form. In fact, an independent analysis of the CFPB's arbitration study conducted by the Mercatus Center at George Mason University determined that the CFPB's conclusions that they drew from their own study on arbitration clauses does not support a case for an ex ante regulation of mandatory consumer arbitration clauses, meaning the conclusion of the CFPB to get rid of arbitration clauses in consumer contracts is patently wrong. Yet they did it anyway.
So do your own analysis. Did the CFPB get it wrong? Or do you think consumers should be forced to retain attorneys, get next to nothing in compensation and fewer payouts that take years and not months? Or is the CFPB working against consumer protection in this case? The absolute truth is, in this case, consumer protection is hurting consumers by getting rid of arbitration clauses in contracts. And it's done at the behest of one person, the head of the CFPB, Richard Cordray. And it's happening right now, right before your eyes. A person with absolute power who's accountable to no one. Let's keep going.
Now, Dodd-Frank was signed into law on July 21st, 2010. Dodd-Frank is the architect and legal document that both created the CFPB and gave clear instruction of the CFPB's legal parameters and objectives.
Dodd-Frank states the CFPB can only make changes to arbitration clauses if and only if the study determines a change is in the public interest and protects consumers. So ask yourself, does the CFPB's very own study that we looked at support a case to get rid of arbitration clauses?
The answer is no, it doesn't. Not even close. In fact, the exact opposite is supported, that getting rid of arbitration clauses in contracts will clearly hurt consumers, not help them, yet they did it anyway.
So this sounds to us like the CFPB is acting outside of its Dodd-Frank mandate. But hey, when there's no recourse, why not? I mean, if that's what you want to do, right? But why? Why would he do this? Why would the director work outside of Dodd-Frank and propose a rule that hurts consumers?
Okay, so let's look at it this way. In the scenario that we just laid out, based in large part on the CFPB's very own study, who's the winners here?
You guessed it, the lawyers. The class action lawyers, just like the class action lawyers who contributed to the Ohio Democratic National Committee when Richard Cordray was the Attorney General, who handed back class action cases from the Attorney General's office that paid out millions upon billions in settlements. Those guys are the ones who benefit from the arbitration ruling by now CFPB Director Richard Cordray.
Peculiar, isn't it? So, back to the Court of Appeals ruling. Indeed, other than the president, The director of the CFPB is the single most powerful official in the entire United States government, at least when measured in terms of unilateral power. That is not an overstatement.
A problem of a single director model for the CFPB, identified by the court's ruling, that offers little in the way of correcting. In short, this ruling, though won by PHH, is a victory for the CFPB and proponents of the CFPB's one-man director wielding absolute power. Yet, now you know why this is a problem. Now you've seen it. It's like the saying goes, absolute power corrupts absolutely. Such is the case.